getting new reaction to the Supreme Court's blockbuster ruling on presidential immunity. In a monumental decision for presidential powers, the court ruled that former President Trump is immune from prosecution over official acts. They specified he does not have immunity for unofficial acts. But the decision has massive implications for presidential powers in the criminal cases against Donald Trump. Hello, everyone. This is Outnumbered. I'm Kayleigh McEnany, here with my co-host, Emily Campagno. Also joining us, Kennedy Saves the World podcast host, Kennedy, Hudson Institute senior fellow, Rebecca Heinrichs, and Fox News contributor and former assistant U.S. Attorney, Andy McCarthy. But we begin at the Supreme Court, where Fox News Sunday host and Fox News chief legal correspondent Shannon Bream is standing by with details on the historic ruling. Shannon.
So, Kayleigh, you heard it this morning. It breaks down this way. The court says there is absolute and presumptive immunity for a president for the official acts or core acts of his presidency. Now, they say that does not extend to criminal activity that is part of unofficial activity for a president. And here's the thing. A lot of people say, well, what about in this case? This is a rule for the ages, as Justice Gorsuch said they were writing. And Justice Roberts, the Chief Justice, writing in his opinion today, say this doesn't matter who's in the Oval Office, what their politics or policies are. This is the blanket finding that we're making. But they do talk a little bit about the various things that are charged in the indictment against President Trump, but say we can't make a finding on those about whether those fit into this official act or unofficial act because this case was expedited. We didn't have full fact finding, full briefing, all of those things. So those of you who are pushing for us to get this done quickly, here's your decision. But what it means, because we don't have that full record, is that it goes back to the lower court. And that means a delay. So if you're a supporter of President Trump, it's a win in that respect. But you have to remember that ultimately the court will probably get to a trial on these specific facts. So the long-term decision is still yet to be seen. The dissent very upset, saying that it empowers people to essentially take office and do whatever they want. The majority responding to that, repeatedly saying the doom and gloom that the dissent lays out for you today is not accurate. We're not saying that people can come in and commit criminal acts willy-nilly, but we are saying this is now our baseline. We send this back to the lower courts. So, Kayleigh, just, it's a hurry up and wait situation now to see how this trial actually plays out.
Shannon, thank you. Andy, I heard you this morning mention that the Fisher case, the January 6th case we got Friday, threw out essentially part of the Jack Smith indictment, or at least put it, aspersions on it, and that there were 7 pages left, that they could go to trial on those 7 pages ahead of Labor Day. But all of a sudden we get this ruling. How does that affect that analysis?
I just think it would be very un-Jack Smith-like to try to break off a little piece of the indictment and say, this is pristine private conduct. It's not informed at all by any presidential authority, and we can just go to trial on that. I don't want to be misunderstood as saying I think that's a simple, straightforward thing. I think if it was a simple, straightforward thing, remember, it happened almost 4 years ago. Somebody would have pled guilty over it. Somebody would have been prosecuted for it. Nobody has been prosecuted on the so-called fake electors scheme. Nobody. So if it was that simple, I think it would have happened already. But the way the court, I think, weighed this and the way they've written the opinion, at least as I understand it, if there's any part of a president's executive authority that is intermingled in the facts, then the judge has to make findings about how much of that can be proved. It's not just, Kayleigh, that he can't be prosecuted, like he can't be convicted. They can't use against him the immunized behavior. That makes it a very different case, evidence-wise. It's not just charge-wise. So it's complicated.
It is. And, Emily, the Supreme Court went pretty far here. I mean, when you read some of this opinion, they talk about the interchange between Donald Trump and the acting attorney general. They go so far as to say this can readily be categorized in light of the nature of the president's official relationship. So that's off the table. That's an official act. They move on to some of his January 6th public statements, and they say Trump's communications in the form of public addresses possess extraordinary power to speak to his fellow citizens on their behalf. So most of a president's public communications are within the outer perimeter. In other words, they took all of this behavior and categorized it, sending the others back to the district court to be litigated.
And contrast that, if we can, not to muddy the waters, but with the gag order that we're hearing. Right here, the Supreme Court, in its very austere and its very elevated position, is saying this is what an executive power looks like. This is what official conduct looks like, and this is the powers that we vest in the president. And I think much has been made, rightly so, about our constitutional articles and that, well, the whole point is to have limited power. And this is true. But the powers that we do vest in the president, we vest wholeheartedly. And that we have also subscribed many ways and many remedies for behavior unbecoming, for illegal behavior. This does not excuse criminal behavior. This does not say, therefore, that a president's reign is unfettered. It is very specific by saying, with these constitutional official acts, with the official acts by the vested constitutional authority for the president, he or she shall remain unfettered and unanviled to do the job that we believe and vest in that person to do so. And all the rest is essentially noise, but exist so that the people do have their voice. And I think what we're seeing here, to my point, is that there's sort of a slap on the wrist occurring. And that every time that we go to the Supreme Court, we are reminded of the austerity of that particular bench and that particular swath of justices. And I think nowadays, and especially with these cases against Trump, it's a stark contrast with what the lower courts are doing and how they are treating him.
There is a contrast. And, you know, Kennedy, the Sotomayor dissent, I think, can be described as apoplectic, hyperbolic. I mean, she goes so far as to say when he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution, orders the Navy SEALs Team 6 to assassinate a political rival, immune, organizes a military coup to hold on to power, immune, takes a bribe in the form of a pardon, immune, immune, immune. This is literally how she wrote. Only problem with that is we have checks and balances in the form of Congress's check on the executive all throughout the Constitution.
Yes, and anyone who serves in the military also takes an oath to defend and uphold the Constitution. So they would be breaking the law in these acts. But she was also equally hysterical in the Grant Pass dissent when she said that people have the right to sleep. So, and I understand that, you know, these are still human beings and they're still political people. But, you know, Andy, this has to give anyone who's running for president a sigh of relief, because this doesn't just cover President Trump. You know, this is not just a political ruling. This is a very important constitutional question that has to be answered for many presidencies to come. So if I were Gavin Newsom or Kamala Harris or Joe Biden, I think I would be very relieved by this.
Yeah, I would say anybody who run for president and anyone who's been president. Because I think the most important thing that may be in the opinion is where they say a court is not going to look at the president's motive.
Right. Because
this whole idea of politicized prosecution, I mean, we've been looking at this now for, I want to say, like 15 years. I mean, going back to the Obama administration's running of the Justice Department. And the thing it's built on, the foundation of it, is this idea that the president, who's the chief executive, can take actions that are undoubtedly within the ambit of executive authority, and then afterwards, some inferior executive officer, a prosecutor, can come in and second guess what the chief executive said or did on the grounds that, well, it may look like it's okay, but I think he had a dirty mind. You know, I think he had corrupt motives. And if they can't do that, then about maybe 8/10 of lawfare is gone.
Wow, 8/10 of lawfare is gone. That's quite something. You know, Rebecca, we've heard about the SEAL Team 6 hypothetical going all the way back to the appellate court. It's something that was brought up there. But there's a hypothetical I don't think that was focused on enough, and that was proposed by Justice Gorsuch. And he said, let's say a president sits outside an official government proceeding in Congress and has a peaceful civil rights protest, but it obstructs an official proceeding, prosecutable. That's the other end of this. If there's not some modicum of immunity for a president, which now we know there is, can you prosecute someone for a peaceful civil rights protest that happens to infringe upon some statute somewhere in the onerous statutes that exist?
And it's a good example. The other thing that I keep thinking about whenever I consider Sotomayor's kind of hysterical dissent is to do a gut check. What was your reaction back in 2014 when Eric Holder, then Attorney General, defended President Obama's executive authority to carry out the drone strikes against terrorists that we knew overseas, but who were American citizens? What was your reaction then? At the time, the Obama administration claimed executive authority. This is a unitary executive. He has to have broad executive authority to do that. Now, there were plenty of people who thought that that was too broad, and then there were those who were very defensive of President Obama at the time. So it's a good gut check, I think, today to see how your reaction is. The other thing I want to say is a great point that Emily made. This really is a defense of the different branches of government. Congress has already litigated through the impeachment trials, January 6th, President Trump's involvement in that. It tossed it over to the Senate. The Senate evaluated it and acquitted him of those particular accusations. So we've already handled this through the proper channels, the political channels, that's Congress.
Yeah, that's exactly right.
Hey everyone, I'm Emily Compagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.